Good morning.
A minute.
Hold on one moment, please. Good morning, but hold on. All right, now you can proceed.
Good morning. May it please the Court. Richard Briansky on behalf of Federal National Mortgage Association and Green Tree Servicing, LLC. The issue presented today is what we have termed the logical extension of this Court's decision in U.S. Bank versus Ibanez, namely, can a mortgagee foreclose without holding the underlying debt?
Can I ask you a preliminary factual question and a legal question that's tied in with it? Is there any evidence here that Ms. Eaton failed to pay either the insurance or the real estate taxes? And if she did, if those are included in the statutory condition, breach of which can result in foreclosure, even if the note were not joined with the mortgage here, could Green Tree have foreclosed for breach of the statutory condition of failure to pay insurance or real estate taxes?
There's no evidence in the record on the underlying court either way. All there was is a breach for failure to make payment, presumably. And Ms. Eaton has been living in that property rent-free without paying the interest, without paying the real estate taxes or the insurance.
So this is purely breach of the note?
Simple breach of the note.
Okay.
At least that's what went forward on the underlying case.
Okay.
Before you gather steam, Monica Medina, the amicus says that Monica Medina was not even an employee of MERS when she supposedly transferred or signed the mortgage, that she in fact was an employee of Green Tree and had no authority to assign the mortgage. Have you looked into that?
The assignment is not an issue in this case. In fact, hasn't been challenged.
Well, the amicus claims it's a fraudulent transfer, that Monica Medina, you've seen the amicus, I trust.
I have seen the amicus.
And you've seen the allegation in the amicus that we don't need to reach the ultimate issue because this was an assignment not by MERS but by an employee of Green Tree. You're the attorney for Green Tree. Was Monica Medina an employee of Green Tree or an employee of MERS on April 22nd, 2009 when she assigned the mortgage?
My understanding, which is standard with MERS policy and practice, is there's typically an employee of the servicing company who is also an officer, been appointed an officer of MERS and has authority on behalf of MERS to execute that assignment.
I take it it's not in this case, though.
It's not in this case at all and hasn't been challenged.
Okay. But so, another question. So does Green Tree essentially, are they in a position to extinguish the debt here?
By that,
Is Green Tree in a position to extinguish the debt?
meaning that if Green Tree doesn't hold the note,
Right.
so whatever proceeds that they collect from the foreclosure sale would be remitted to the note holder.
Okay. Under what rule?
Well, I would say under what rule? Under the rule that's been articulated by this court and has been, I think, around for about 150 years. That these proceeds are essentially held in trust for the note holder, and the note holder can compel those proceeds. There is a fiduciary existing relationship between the mortgagee and the note holder.
So would they pay the money over to the note holder, or do they file a bill of interpleader and list all subsequent, anybody else that has an interest in the property, any lien holders?
Well, the money will go directly over to the note holder.
And what if it doesn't? Where does that leave? Let's just assume this foreclosure sale went forward, and Green Tree doesn't give the money, and then the note holder sues Ms. Eaton on the note. What does she do then? She has to, what does she do?
Well, two things, Your Honor. I think it's not an action against Ms. Eaton. It's an action based on breach of fiduciary duty against the mortgagee. Secondly, in approximately 150 years that this has been ongoing, and in particular these last 6 years, there's not one case where the mortgagee has foreclosed and there's been an issue about a secondary or double liability, the policy issue which is articulated by Ms. Eaton in her brief. You would think that if this was such a pervasive concern, that this issue would have been raised in several actions, particularly in the last 6 years, given the foreclosure crisis. But there's not one case where there's been an issue of double liability, and there's no facts to suggest the issue of double liability exists here today.
Who determines whether or not to foreclose in this case? I mean, who's collected the payments over time, and who decided that the payments were not coming in, and who decided that it was time to foreclose on Miss Eaton's mortgage?
Well, this is all handled by a servicer who has...
No, but identify, please. In this
note,
case,
note holder
identify.
versus mortgagee.
Just identify who it is that would have made these decisions along the way in this case.
It would be the servicer who has authority to act on behalf of the note
Is
holder.
that Greentree?
That's Greentree.
So Greentree would decide, because Greentree has been collecting the payments?
Yes, and remitting them to the note holder.
So Greentree's been in the position all along of knowing whether or not the loan was current or not current?
That's correct.
And Greentree alone, without anyone else's say-so, decides whether or not to foreclose?
Well, there's a contractual relationship between it and the note holder.
Well, but does it make the decision after being advised by the note holder to do so?
No,
Or does
it has discretion.
So the note holder couldn't take a different position. The note holder couldn't say, well, I think we should collect on a different schedule, or we should forgive some of this. That's not within the note holder's power to do?
Well, it all depends on the contractual relationship between Greentree and the note holder. If you're talking in terms of modification of the underlying note itself, if there was a request for modification, that request is submitted to Greentree. Greentree has a certain amount of discretion with regard to the adjustment of principal and interest, but this is based on its contractual relationship with the note holder.
Who was the note holder at the time of default?
It was Fannie Mae or Federal National Mortgage Association.
And who declared that there was a default?
Greentree.
Greentree, the mortgage holder, declared there was a default on the note.
Well, Greentree is acting as an agent for the note holder. It is in the principally standing as an agent for the note holder.
Okay, and where is there anything in the record that reflects that?
I would look at the mortgage itself that was signed by Ms. Eaton, which specifically recognizes that MERS, its successors or assigns, are acting as mortgagee, and that there's a specific agency relationship articulated in that mortgage signed at origination. This wasn't some clandestine deal. Ms. Eaton knew at the time of origination that a third party who was not the note holder was going to have the statutory authority to foreclose on her property.
Let me- Oh, I'm sorry.
Sorry, go
Finish
ahead.
your thing. Well, I just wanted to ask you about that precise point. I'm looking at the mortgage, it's 14 of the appendix, and it says, so this is an argument that the Ms. Eaton makes, that if necessary to comply, it says that MERS holds only legal title to the interest granted by the borrower in this security instrument, but if necessary to comply with law or custom, MERS, as nominee of the lender, has the right to exercise any or all of those interests, including the right to foreclose and sell the property. So I guess the question is, what makes this necessary to comply with law or custom?
Well, and I'm going to answer that two ways. First, Your Honor, the mortgage also conveys to MERS, its successors, and assigns the statutory power of sale. That, in and of itself, gives us the authority to foreclose under the statute. That particular justification.
This is the language you cite in your brief.
We also cited the predecessing language, if you look at it. For this purpose, borrower does hereby mortgage grant and convey to MERS as solely as nominee of the lender, its successors and assigns, and to its successors assigns with the power of sale. So we claim both to be the mortgagee and we have the right under the power of sale, which was not addressed by Ms. Eaton.
You have the right beyond that of a nominee, or you're claiming that the definition of nominee encompasses something broader than its ordinary understanding?
Well, I think we have the right to foreclose. If we hold title to the mortgage, and if we held
And you're
and all the
essentially a
legal
straw,
rights,
but you have but you're arguing a greater stake as a nominee. You're arguing an agency, and for both the lender and the mortgage.
but isn't a nominee by
Mortgagee.
definition an agent?
Well, you tell me. You think that it is based on what?
based on the language and the relationship that exists between these three parties, this is really a tripartite agreement. I mean, you have the lender, you have the mortgagor, and you have a third party who's holding the note. Sorry, you have
No, you haven't.
Sorry, you have the lender, you have the mortgagor, and you have this mortgagee who is holding the mortgage or the security interest and is subject to the conditions in this agreement. That mortgagee has been given some discretion and some rights under this very contract, which was executed by Ms. Eaton. Those rights include the statutory power of sale and the right, if necessary, to comply with law and custom, which I think is basically a belt and suspenders language. It's additional language in there to allow MERS or its successors and assigns to foreclose if it is necessary. And to address your question, I think that gives discretion to the mortgagee to determine whether if it is necessary to comply with law or custom.
Mr. Briansky, one of the amicus briefs suggests to us that that it's established law in Massachusetts that in order to foreclose, that there must be both the note and the foreclosure together. And here are the two cases: Walcott versus Winchester and Crowley versus Adams. And we're told possession of the debt is essential to an effective mortgage. Without it, one cannot maintain an action to foreclose the mortgage. And in Crowley, they say possession of the note is essential to an enforceable mortgage, without which no mortgage could effectively be foreclosed. That goes back to 1860 in Massachusetts. You agree with that?
I don't agree with the conclusion. I think that the SJC in both of those cases, which we've articulated in our brief, is focused on the underlying debt itself, and we would agree with the general proposition that a mortgage is not enforceable without the underlying debt, meaning that if there is no debt, if the debt is extinguished, there's no right under the mortgage.
Do you agree
But
that...
that's what the focus is on those two SJC decisions. In addition, what's not articulated in that brief, and what I think factually distinguishes this case from all of those 18th century cases, is the very mortgage that we are discussing today, which vests a third party with rights. That is a critical fact which is completely is not discussed in any of these cases.
Do you agree that that if Ms. Eaton had not been in default on the note, she could have brought an injunction or sought an injunction to prevent the foreclosure?
If Ms. Eaton had not been in default, yeah, of course.
I'm sorry?
Why?
If she had not been in default on the note, do you agree that she could have instituted a civil action for injunctive relief to prevent the foreclosure from proceeding?
Because there was not a breach of...
Is that a yes or no?
Yes.
Did she bring such an action in this case?
Before foreclosure?
Yes.
No.
Okay. And had she been making payments to the servicing agent, Greentree?
She was in default at the time of foreclosure.
But had she ever made a payment to Greentree?
Yes, there were payments to Greentree.
Did she get notice of the foreclosure?
Yes, we complied with all the statutory prerequisites, and there's no allegation that we have not.
So she could have brought a civil action to enjoin the foreclosure on the grounds that she allegedly had been current on her note, and she did not bring such an action.
She did not, that's correct. Okay. It was all post-foreclosure and an attempt to evict her from her house.
Just go back a little bit to something you suggested, that in the last 6 years there's never been a case where that somebody has established that the disunity between the note and the foreclosure has caused some problem. This is an unusual circumstance created in the last 6 years by this entity, MERS, which holds these unusually, certainly in the history of the Commonwealth, separately, and only occasionally do you have a mortgage holder, a mortgagee, separate from the note, and they're quite unique, those circumstances. Isn't that a part, possibly, suggested by the cases we have heard, because of the kinds of people who are in this situation where they wouldn't actually bother going after them, so that you don't have the issue that somebody says, you know, they don't go after them because they don't have any money anyway, and there's a disincentive to do it by the structure of the fee arrangement. So the usual, at least one of the amici suggests, and it makes sense given the cases we've seen, isn't also because of the service Greentree, someone in the shoes of Greentree, doesn't really have an incentive to make sure that the mortgage is paid, but rather has a greater incentive just to foreclose. charge the fee, which could be substantial, so that there really is nothing left to seek. I mean, is it partly just because we haven't seen the unusual circumstance? You don't suggest that it couldn't happen, that the fact that the note is separated could cause a problem with the fact that someone might still have O on the note.
No, it would be a possibility, but my suggestion is simply this. I think that this is a procedure where you've seen many cases articulating specific procedural defects which have gone to various courts, both in the Commonwealth and throughout the United States, attacking the foreclosure process on various different levels and attacking the securitization process. And you haven't seen one case where there's this double liability issue where you've conceded, and I think we have to acknowledge that the mortgage industry has changed significantly and that this third-party MERS has been holding and foreclosing on notes. In fact, the vast majority of jurisdictions which have considered this issue, whether a mortgagee can foreclose without the note, have all allowed MERS, which never holds the note, to foreclose.
You're just saying that's old news. This unity idea doesn't have any application for the future, and this is the way it's going to be, regardless of whatever the reasons might have been, good ones, perhaps, to have them together. This is an appropriate way to proceed for all purposes because it's never happened in 6 years.
Well, that's not, I'm suggesting there's neither a statutory nor contractual prohibition against it. So if there is neither contractual nor statutory, what's to prevent a mortgagor from entering into a contract, vesting a third party with those rights, and allowing the third party and the lender to work together to foreclose?
So I take it one of the things you're suggesting is that at least in view of this tradition of 160 years, since that time, the legislature has enacted Chapter 93A. There could be double or triple damages plus attorney's fees for any attempt to collect double on a note, which appears to be unconscionable on its face.
That's certainly a remedy that would be available to the debtor in the event that would happen. But in this particular case, there's not even evidence that we went after, that Greentree or Fannie Mae went after a deficiency. And there's no dispute from Ms. Eaton. She concedes that she defaulted on the note. So aren't we in the same place that Ms. Eaton anticipated on being in at the time she signed that mortgage, meaning that if she didn't pay and if she didn't comply with the conditions precedent, that a third party, in this case it was Greentree as a successor to MERS, would have the right to foreclose and take her property, and isn't that specifically what happened? And there is no allegation and there's no facts to support any double liability issue. Greentree, Ms. Eaton has been in that property for now almost I think the foreclosure occurred sometime in 2009. It's now 2011, and there's been no allegation of some third party attempting to collect a debt.
What would stand in the way of mayors simply contacting, in this instance, Fannie Mae, and Fannie Mae's own regulations permit the note going to be reunited with the mortgage? What would preclude that from happening? Why is that a problem?
Reuniting the note in mortgage?
Yes.
I mean, conceptually, I don't think. Oh, at the
So
time
it could be done. It could be done.
Well, it's of course it could be done. Yes, it could be done. I'm not so familiar with Fannie Mae's guidelines that I could tell you whether there's a particular guideline which prohibits it or the justification for that guideline. There very may well exist, and I'm not prepared to discuss those because of my lack of familiarity.
Going back to the assignment, the mortgage assignment says that MERS, as nominee for Bank United, assigns and transfers to Greentree Servicing, but makes no reference that Greentree Servicing is acting as an agent or nominee of anyone. Why are you saying that it's plain from the record that Greentree Servicing is acting as an agent of Fannie Mae? Where is that in the record, apart from you telling us?
Greentree is taking as a successor and assigned to MERS, so whatever the terms of the mortgage were at the beginning would still exist and bind Greentree. So Greentree's rights are limited to whatever's in that mortgage.
Right. The original mortgage says MERS is a mortgagee under the security instrument and is a nominee for the lender. So you're saying that when a nominee for the lender assigns it, it assigns it as a nominee for the lender, and that the assignee remains the assignee for the lender?
Yes.
Well, thank you, counsel. We'll have to
Thank-
leave it there. Thank you.
Mr. Chief Justice, Associate Justices, and may it please the Court. My name is Sam Levine, SJC-303, and I, along with my supervisors David Grossman and Esme Caramello, are representing the appellee Henrietta Eaton. For 150 years, foreclosure in Massachusetts has been governed by a simple but effective rule. An entity wishing to foreclose on a mortgage needs to hold both the debt and the mortgage securing it.
Mr. Levine, is there a, Mr. Briansky says these 19th century cases are cases in which the debt had been extinguished. Are there, and I should know this, but I don't, are there cases in which the debt had not been extinguished, but the same result obtained because the note and the mortgage were not united?
There are, Your Honor. Both Wolcott v. Winchester and Howe v. Wilder are cases in which the debt had not been discharged. And Howe v. Wilder, I think, is particularly apt because this was a case in which two parties both claimed title to the mortgage, but only one party held the debt. And this court held that because that second party didn't hold the debt, it could not maintain an action to foreclose. In fact, this court said that the common law expressly prohibited, and that's the language from the opinion, foreclosure without a note. That rule was reaffirmed in Wolcott v. Winchester and in Crowley v. Adams and codified in the UCC.
Well, why shouldn't that rule change in light of, after the passage of 150 or 160 years? Commercial transactions have become more complex, and the common law often adapts to changes in commerce. What's so critical about having the note and the mortgage holder be one and the same person?
Well, I think, Your Honor, it's proven to be a sound rule, particularly in modern times. In fact, I think the logic underpinning the rule is stronger today than ever. It makes sense. It's particularly in light of the amicus brief talking about the mixed incentives and everything like that. It makes sense that a party making a decision about whether to foreclose actually have an interest in the debt. After all, in fact, there is no evidence in the record that Greentree had any relationship to the note holder. So a bare holder of the mortgage, under the rule proposed by appellants, would have the power to foreclose, but not the power to modify the debt.
Well, but you can foreclose for reasons other than the underlying debt. You can foreclose, at least under the statutory conditions, if the mortgage is on those terms. You can foreclose for failure to pay any insurance on the property and failure to pay real estate taxes, having absolutely nothing to do with the note.
I think it's a fair distinction, Your Honor, that it's possible that there are certain terms in the note that may be enforced independently. But the term at issue here is the promise to pay principal and interest. Those terms are not even laid out in the note. They're laid out, they're not even laid out in the mortgage. They're laid out in the note. So the statutory condition that was breached by Ms. Eaton was a condition in the note. And it should therefore be the note holder who makes a decision upon default, whether it makes more sense to foreclose or to pursue another option.
Mr. Levine, what do they do in other states?
It's important to note, Your Honor, that no high court that I know of in the country has adopted the rule proposed by appellants. And indeed, we've pointed in our brief to both judicial states like Maine, which is, by the way, a title theory judicial state, and non-judicial states like Nevada and Arkansas and Texas that have required unity of the note and mortgage because it's a sound rule.
But you have a plethora of bankruptcy decisions and other decisions which seem to go the way that Mr. Briansky says. So what are they basing that on? I mean, from other states and this state. I mean, bankruptcy decisions.
Your Honor, none of the bankruptcy decisions in Massachusetts have acknowledged Howe v. Wilder. None of the bankruptcy decisions in Massachusetts have acknowledged the role of the UCC, which governs the enforcement of negotiable instruments.
But if I could ask, let's assume that you have a note holder who decides it does not want to get into the dirty business of holding the mortgage and of foreclosing, so it retains an agent, a different entity, and says, we give you have the mortgage, and you act as our agent, and you act at our direction. Would that be permissible?
If the principal actually transferred the note to the agent, and the Fannie Mae's own servicing guidelines instruct.
Well, let's assume it did not. Let's assume the principals held on to the note but said, I retain you as mortgage holder. I transfer the mortgage to you, but you act only at the note holder's direction.
I'm not sure that would be permissible, Your Honor, but I would make a quick note that there's no evidence of any servicing or agency relationship in the case at bar. But in the hypothetical
Mr. Bransky claims there is. Mr. Bransky claims that when MERS transferred or signed the mortgage, it assigned it essentially as nominee, and therefore its agency relationship continued.
I would point out two things. First, that there's no evidence that there is three things, Your Honor. First, that there's no evidence that a nominee is the same as an agent. And courts that have looked at this, including the Supreme Court of Kansas and the Supreme Judicial Court of Maine, have expressly rejected that proposition. Second, there's no evidence that whatever relationship existed between MERS and Fannie Mae was passed on through the assignment of legal title to Greentree. Thirdly, Your Honor, I would point out that even if Greentree did receive all the rights that MERS had under the mortgage, they're still bound by the restriction that the mortgage places on the lenders, which is to say that they only may foreclose if necessary to comply with law or custom. These are three restrictions on Greentree that I believe either any one of them would independently preclude them from foreclosing.
Would you, and maybe you just did say this, would you also say, this is Justice Gantz's earlier questions, that, well, I should ask you this, is there anything in this mortgage instrument that says MERS can assign its interest as nominee to somebody?
No, there is not, Your Honor.
Well, it's to the successors and assigns of MERS. So what's granted to MERS is granted to MERS and the successors and assigns of MERS. Or am I misreading this?
Well, I believe what that passes on is legal title, Your Honor.
And the power of sale.
But I think that the power of sale is limited by the text below that says it can only exercise.
But it's passed on.
It might be passed on, Your Honor, under the terms of that contract.
And so
Well,
why? I mean,
it says successors and assigns of the lenders. I don't see that it's of MERS.
Right.
Maybe I'm wrong.
And that's an important point about this mortgage, Your Honor. In different parts of the mortgage, MERS defines itself in different ways. But if we look on page 14, it says MERS is the nominee for lender and lender successors and assigns, and that MERS may foreclose if necessary to comply with law or custom. I would submit that the clearest way to read this mortgage is simply to turn to page 24 in the record, which is paragraph 22 of the mortgage. That actually is the power of sale. It's all in bold. And it says the lender may accelerate the debt, the lender may publish notice, the lender may send notice to the mortgagor, and the lender may foreclose. And that's consistent with the common law.
But hasn't the signer of the mortgage agreed that MERS can exercise the power of sale? Have they agreed to that?
I would submit that even if in the four corners of the mortgage Ms. Eaton had agreed to it, and I don't believe she has because of the restrictions that I referenced, but that even if she had agreed to that, she didn't waive her protections of the common law, and she didn't waive the protections of the UCC, and she didn't waive all the rest of Massachusetts authority going back 150 years.
But didn't she waive it? I mean, at least in the sense that she didn't avail herself of the well-recognized remedy of seeking injunctive relief to prevent the foreclosure from taking place.
Well, I'm not sure she would have been in a position to seek injunctive relief because if Greentree didn't have the note and Greentree had no relationship with the note holder, Greentree was in no position to make a decision about whether to foreclose.
Well, but they did.
Well, that's exactly a reason to seek an injunction for.
I think
But she didn't do that.
No, she did not seek an injunction, Your Honor, and I think it's understandable that borrowers in this state and this Commonwealth don't know who actually has an interest in their note. If Ms. Eaton, for example, had called a party like Greentree, who only had a title to the mortgage, Greentree would have said, we don't have the power to modify your loan, we don't have the power to discharge your debt after foreclosure, but we do have the power to foreclose.
Why do I need to know? I mean, I have a mortgage. Why do I need to know who holds the note eventually? I have to pay my mortgage. There's a place to which I pay my mortgage, and if I don't pay my mortgage, I'm in default of the mortgage and the note, and I can be foreclosed on. Why do I have to know who in the chain of financial services holds the note? Why is that important?
Well, aside from that, it's required by law that a note holder be the one exercising the power to foreclose. I think it makes sense that borrowers as a...
Oh, you say that. Go ahead.
Yes.
It makes sense that borrowers...
And I also think it makes sense that borrowers know who actually has an interest in the debt. And I would point to the example of Nevada, which is a non-judicial state, and the Supreme Court required that in the mediation program created by the legislature, that if a lender comes to the table, that lender needs to prove they hold the note.
So your client didn't know that Fannie Mae held the note?
Certainly not, Your Honor.
Almost everything is... Well, I thought almost everything was resold.
I don't think my client understood that. What my client understood...
And it's important that she understand that. Why?
Well, because I think she's entitled to the terms of the contract and to the law, Your Honor. She took out a loan.
And didn't pay it?
Pardon me?
She took out a loan. She didn't pay it. Okay.
But it matters who she didn't pay. The fact that she defaulted on a loan doesn't give anyone a right to take her home.
Well, it gives the holder of the mortgage and the power of the sale the right to foreclose. Isn't that what it's all about? Isn't that what a mortgage is?
No, I think foreclosure is actually, Your Honor, respectfully, all about the note and all about recovery of the debt. The debt is the principal. The
So if you have a note without the mortgage, you certainly can't foreclose.
That's true.
Right. It's the mortgage that gives you power to foreclose.
Well, under the implied trust relationship that this Court recognized in Ibanez, because the note is principal and the mortgage is incident, the note holder could sue for an assignment of the
So you're
mortgage.
saying this would all be okay if it was only Fannie Mae that foreclosed, and somehow that makes a huge difference.
If Fannie Mae had assignment of the mortgage and the note, then Fannie Mae could have foreclosed. But we should note in this case, the record is important in this case, because the record is what's going to determine the rule that appellants are asking this Court to adopt. The record has no information about who holds the note.
Who was Ms. Eaton paying her mortgage payments to?
I presume that it's not on the record, Your Honor, but I take the counsel's word that she was paying to the servicer. But we have no idea who was actually collecting those payments. And we know, Your Honor, that under the UCC, which governs these payments, the only way those payments would actually be set off against the outstanding balance and that they would actually be discharged in foreclosure is by the actual owner of the debt, by the actual note holder.
Well, was she making do we know in the record whether she was making her checks payable to the servicing agent or to the original mortgagee?
That's not on the record, Your Honor.
And you're asking for equitable relief?
We're asking for equitable relief because we have no idea in this case who Miss Eaton defaulted on her debt. We have no idea who owned that debt. We have no idea whether that debt has been discharged.
But you were making checks payable to somebody, and you're not saying they were made payable to the wrong person.
We don't know that, Your Honor. It's not in the record. And even if, upon remand, it's discovered that Greentree, if this case were remanded and it were discovered that Greentree was acting on someone else's behalf, on the record before this Court, we have no idea where Miss Eaton's checks were going. We have no idea whether those checks were being set off against the principal she owed. And under the rule they propose, whereby the debt is irrelevant, and all that matters is legal title of the mortgage, that will be the law in the Commonwealth.
Let me ask you this. I appreciate your argument about the limitations in this language, but if the mortgage itself had language which made it crystal clear, not ambiguous, that there is going to be, that the mortgage is going to be conveyed to MERS, and crystal clear that MERS, as it probably is, has the right to assign it to somebody, and crystal clear that what MERS has is the right to foreclose for any of these conditions as nominee. You say, well, that doesn't deal with the common law, but if it's a contractual relationship, you're saying because it's sort of on a Toscano theory that it's against public policy that you couldn't contract for that?
Well, like Justice Gantz, I believe it was Justice Gantz or maybe Justice Link who pointed out, she could contract for it, but MERS would need to be transferred the note in order to foreclose.
Because of what you say, because of this unity that you say the common law requires, right?
Yeah,
So you're saying it would be against public policy to have a contract that explicitly didn't require that. Is that what you're saying?
I think it would not only be against public policy and likely unenforceable, but even if you could imagine a contract that were enforceable, Ms. Eaton would have to say explicitly that I am waiving the common law protection that says you need the debt to foreclose. I'm waiving the UCC. And I would point out something about this contract, Your Honor, that's important. This contract, particularly the note, is governed by the Uniform Commercial Code. That was the whole basis.
The mortgage, why is the mortgage governed by Article 3?
The mortgage isn't, Your Honor, but foreclosure is an enforcement of a note. Foreclosure is an enforcement of...
How is foreclosure an enforcement of a note?
Because it's an attempt to recover a debt, Your Honor.
But there are statutory limitations on what you can recover.
There are.
And having nothing to do with the UCC, but having to do with statutory procedure.
But the UCC continues to govern the enforcement of notes and provide important protection for borrowers. The whole basis on which Ms. Eaton's note could be endorsed in blank and pass from one lender to another lender is the UCC. Along with those protections from creditors, which also include holder and due course doctrine, are very basic protections for borrowers that say in order to enforce a negotiable instrument like a promissory note, you need to be the holder, and that in order to discharge a promissory note, you need to be a holder.
But one of the big differences between a mortgage and a security interest under the UCC is that a mortgage is title. It's not just a security interest. Massachusetts has a title theory. It's entirely different than conventional states or than the majority of states that follow the lien theory. It's an entirely different animal.
Well, I'm not sure the title theory is what matters here, Your Honor. Maine is a title theory state. Nevada is a title theory state. All of these courts and other courts have invoked the UCC to point out that if you're going to enforce that note, and as you pointed out, the obligation that Ms. Eaton defaulted on was under the note. If you're going to enforce that note through the remedy of foreclosure, then you need to be governed by the UCC, which governs the enforcement of notes. I believe that's a sound rule. It's been a sound rule in this Commonwealth for 150 years. And I think even if we turn to the terms of the contract, it's clear that Green Tree, having no interest in the debt, had no right to enforce that debt through foreclosure. And we see in total that the Uniform Commercial Code, 150 years of common law, and the terms of the mortgage contract are aligned in requiring that in order for an entity to foreclose, it needs to both hold the mortgage and have an interest in the debt. That's a sound rule that has served this Commonwealth well.
Thank you, Counsel.
Thank you, Your Honor.